Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This evening I'm looking at a book which has come to us from Jordan's. It's Jordan Publishing Limited in Bristol. The book is called Mental Capacity, Law and Practice, now in the third edition. We reviewed it before. It's a first-class book. It deals with a very, very difficult issue and it deals with it extremely competently. The general editor and contributor is Gordon Ashton, OBE. And the main contributors to this work are District Judge Mark Marin, Claire Van Overdyke, Alec Ruck-Keene, Martin Terrell and Adrian Ward MBE. The title that we have allocated for our review, Elizabeth and I talked about this book as we had with the previous one. We gave this title for the review, which is going to be in the journals and on the web. The definitive work of reference on mental capacity, now in a new third edition. That's what it is. Trying to keep it relatively simple. It's a heavy book. It's a paperback. Purple cover there. There we go. There's the front of it. There is the spine. And there is the back. And you can see there's a lot of detail in there. The book itself runs to something nearly 1,000 pages. Just under. Around about 1,000. There is the index. It's a very detailed index. Very much the house style of Jordan's, I hasten to add. There is the main front page there. Then we go from the front page. There's a very sensitive dedication there, which I'd like people to see. I always like to point out the dedications. It's an important one, that, I feel. There's a preface to the first edition, which is set out, and it sets out what has been happening to the law in this area for some time. It looks also at the concept of the secret court, as it's being called. There are the contents sections. We run through the various chapters in some detail, I hasten to add, running all the way through. Then at the end you get a number of appendices which you can see listed at the back. You obviously have to have the legislation, so you've got the Mental Capacity Act 2005 and the Codes of Practice and the DOLS, the Deprivation of Liberty codes. Then you have the table of cases and then various other details, the statutes of course which are there, and then after that you have some statutory instruments which we can't forget, and then some European material which is always now gradually creeping into what we do. I do find the list of abbreviations of some help, because that will assist you in trying to work out sometimes what they're talking about, because I find it difficult. Then we get to the structure, the background, preliminary matters. You can see that it's paragraph numbering to find things easily. You've got the nice footnoting at the bottom, and then it runs all the way through. And you should find, for instance, here we go, this is healthcare matters and the position under the MCA. You've also got, as I say right at the back, a detailed index. The index is actually for use with the paragraph numbering, which I think you again will find quite helpful. There's a lot of very, very useful practical information here. Now this is what we say about the book. Now in its new third edition, from Jordan's, the book has become the definitive work in an area of law which, because of its complexity and sensitivity, demands careful, concerned and precise analysis, and that's exactly what you get here. And to this end, the book indeed delivers authoritative advice and guidance to often perplexed and pressured practitioners. It's not an easy area of law to be involved in, and it is a terrible area if you are the client. The spirit of the book is illuminated quite touchingly in the introductory comments by its general editor, Gordon Ashton. Covering the Mental Capacity Act 2005, he says, "We must never forget the fact that it is for the benefit of that person, not the lawyers, that this valuable jurisdiction and the Court of Protection exists." I think that's an important starting off point as a preliminary. And it's sobering, of course, to recall that in the 10 years since the first edition of this book was published, the problems of diminished mental capacity have, with an ageing population, markedly increased, rather, I think I should say. In other words, have gone up. We had a lot of it, and it's going to get worse, so I think we ought to be aware of that. The figures, again, don't really give us the actual problems, but only the ones we certainly know about. Now, Ashton has remarked in the preface to the first edition, which is in the front, that the legal rights of individuals who lack the capacity to pursue them must be addressed, but this can only be done in the context of support and care provisions, which become the ultimate responsibility of the state. Clearly, the burdens of responsibility then are on those who are involved professionally in this field, and they are very heavy indeed. And that's really why we need books of this substantive magnitude, because it is a very, very detailed book and an extremely helpful book. There are a lot on the market, and this is probably one of the best to actually explain it under the careful editorship of Gordon Ashton. Now, helpfully, the analysis, commentary and practice advice in the edition, which covers about 1,000 pages, is augmented by the final 400-page section, which contains the 3 appendices, which makes up quite a bit of the book. That's the text of the Mental Capacity Act 2005 as amended, and the supplementary codes of practice. And the book also includes the numerous and important changes that have taken place quite recently. Ashton's team of experienced contributors cover the latest developments in legislation, procedure and case law. Deprivation of liberty safeguards, I think, are very important. They're examined very well indeed, together with the judicial re-ex procedure and the UN Convention on the Rights of Persons with Disabilities. I think it's also important to note the new chapter on other jurisdictions, an important development. It's a vital addition if you need advice on cross-border matters, especially those pertaining to habitual residence and enforcement. And a substantial segment of this chapter is devoted to Scots law and the Scottish courts, as well as related issues in Ireland and Northern Ireland. Scotland in particular being a country in which frequent inward and outward mobility is the norm, and that's something one has to take into account. These discussions will of course be of special interest to private and to international lawyers. And another notable feature of the book is its ease of use. Paragraphs, as I say, are numbered throughout. The footnoting is meticulous, and there's an index, a very good index, the detailed table of contents at the front, which makes important subject matter easier to look up. The abundant research resources include tables of cases, statutes, SIs and European material. Let me conclude by saying this, because I think this is an important book for you to have in your practice. With its lucid and compassionate approach to this difficult area of law, it's a distinguished and certainly up-to-date work of reference here. Chancery practitioners, non-contentious lawyers and family practitioners, as well as local authorities and healthcare professionals, will certainly consider it to be an absolutely essential purchase. And the publication date is cited at July 2015. Let's just have another look at it. There it is there. Paperback, as I say, that's the spine, and then you've got at the back some detail on the authors. But just opening it in the middle, you can see it's a heavy book, and this is all about the Public Guardian and supporting services. You can see just opening it up right in the middle, dealing here with the Court Funds Rules 2011. Court funds being an important area for many of us, because it overlaps with other areas of practice, of course, as well, like PI, RTA matters and so on. There is the footnoting, you can see at the sides there, and then you can see the paragraph numbering quite clearly, and that actually helps you when, if you go to the back and you're looking for a particular thing in the index, you can actually see the paragraph numbering quite clearly there. So that just shows you how to use the book, so you get used to it quite quickly. I did find the contents at the front, the detailed contents sections, to be also very helpful in depending on what you're looking for when you're instructing. But it's an excellent book. I'm extremely grateful to Gordon Ashton and his team for continuing to produce this work. It does make our lives a great deal easier as practitioners when we have works of this nature to read and rely on. So thank you to everybody concerned, and to Jordan's, of course, for publishing it. Bye-bye.